lawyer on behalf of the police. On May 17, 2007, 3 Cleveland, Ohio police officers arrived at the home of Perry Davis, accusing him of harboring a person wanted for questioning and charged him for concealing narcotics in his home. Perry Davis refused to let the police into his home without a search warrant. Police maintained a watch until reinforcements arrived. When they knocked on the door, an 11-year-old boy, Sean, who is the son of Perry Davis, answered. The police presented the warrant to Sean. While it wasn't signed by a judge, the police believed it to be and asked him if they could search the premises, and Sean agreed. When the officers entered the house, Perry Davis demanded to see the warrant. He snatched the paper from the officer, but the officer removed it from the hands of Davis. A search of the bedroom produced a 3-pound bag of a substance believed by the police to be cocaine. Mr. Davis said it belonged to a former tenant.
If the officer was unsure about the warrant's validity, why proceed without verifying?
Firstly, the judge testified that she reviewed and approved the warrant. Although it was unsigned, the officers had every reason to believe it was valid based on her verbal approval. The officers were also invited in by Davis's 11-year-old son, Sean. Courts have upheld searches based on voluntary consent before, regardless of age. Sean was shown the warrant and willingly allowed officers into the home. Officers were in no way acting in reckless disregard to the Fourth Amendment, protecting individuals from unreasonable searches and seizures, requiring law enforcement to obtain a warrant based on probable cause before searching a person or their property. The officers followed all proper protocol by obtaining judicial authorization before proceeding with the search. There is no evidence officers purposefully used an invalid warrant or acted dishonestly. They believe that the warrant was properly executed and that they had every right to search the home.
Do procedural errors automatically invalidate police officer searches based on good faith?
Procedural errors such as a missing signature on a warrant do not automatically invalidate a search when officers act in good faith and reasonably believe the warrant is valid. Under United States v. Leon, the good faith exception to the exclusionary rule allows evidence to be admitted if officers rely on a warrant they reasonably believe to be lawful. In United States v. Leon, good faith reliance, the Supreme Court established the good faith exception to the exclusionary rule, meaning evidence obtained in reasonable good faith reliance on a search warrant later found to be technically deficient is still admissible in court. So evidence should not be excluded when law enforcement officers reasonably rely on a warrant that is later found to be deficient.
Are there any other Supreme Court cases where the child answers the door and the police believe that they can search the house?
In Illinois v. Rodriguez, the Supreme Court ruled that police officers may lawfully enter a residence without a warrant if they reasonably believe a third party has the authority to consent, even if it is later determined that the third party lacked such authority. When the officers arrived, Sean Davis, an 11-year-old resident, answered the door and allowed them inside. The officers could have reasonably believed Sean had the authority to consent to their entry as he lived in the home and did not object. Illinois v. Rodriguez establishes that even if Sean lacked legal authority, the search remains valid if the officer's belief in his authority was reasonable at the time.
We, the defense, believe that our client, Mr. Perry Davis, has been wrongfully convicted on the grounds of improper search and seizure procedures. Mr. Davis denied the authorities entrance to his home, and since they did not possess a warrant, nor could they invoke probable cause, they had no legal jurisdiction to search his property.
Did the police not gain consent from a resident at the home?
The officers on scene produced a false warrant, manipulating Mr. Perry's minor child, Sean Perry, into granting them access to the home. This minor was coerced into allowing them onto the property, as an 11-year-old child would not understand the legal rights in such a situation and could easily be intimidated and misled into implicating the plaintiff of criminal activity. The warrant produced by the officers present had not been seen or approved by a judge, as there was no signature to designate its legitimacy. Physical confrontation that occurred when Davis was asked the officers to procure the warrant only proves its illegitimacy, as there would be no need for such an escalation if the officers had the legal right to be there.
Was probable cause involved in this case?
In order for a warrant to be considered legally valid, it must be issued by a neutral magistrate and signed off by an impartial judge, as well as supported by evidence-based claims, which would suggest probable cause. The officers produced an unsigned warrant in order to gain access to the property, a document that was later proven to be illegitimate after this false warrant was used to arrest and convict Mr. Davis. The fact that he was detained using a false warrant is blatant violation of his Fourth Amendment rights, and it should annul his prior conviction. Although the judge who oversaw the case claimed that she saw and approved the warrant, due to its lack of signature, the document is not legally binding in any regard. Her memory-based testimony does not hold up in comparison with the cold hard evidence, the simple fact that the warrant remained unsigned and illegitimate. The police present were able to access the property on the grounds that Perry's minor child gave them consent to conduct a search, but this behavior was inherently extrajudicial and wrong-headed. Parents and guardians are the only ones who have legal authority over their own homes, as underage children are considered to be dependents. Any legal documentation signed or approved by a minor is not legally binding, and minors are legally obligated to have a parent or guardian present when facing questioning by officers of the law. The young Sean Perry was too naive to understand what inalienable rights he was waiving by allowing the officers to enter his home, and was forced to implicate his father on the basis of this manipulation.
Officers believed the warrant had been approved. The judge testified that she reviewed and approved the warrant. Although it wasn't signed, the officers had every right to believe it was. A missing signature on the warrant doesn't make the search malicious or negligent.
Were the actions of Perry Davis an indication that he did not want the police to search his house?
In regards to Perry Davis snatching the warrant from the officers, this further proves the client's guilt. The act was disrespectful and doesn't prove that officers knew the warrant wasn't signed. They acted against disrespect. The warrant not being signed was a technical mistake, not a constitutional crisis. The judge made an honest mistake and thought that they had signed the warrant. The officers were not acting dishonest and were just doing their jobs. Davis was guilty regardless, and a conviction shouldn't be overturned.
After careful review of the facts, legal precedent, and the arguments presented by both the prosecution and defense, this court finds that the search of Perry Davis's home on May 17, 2007 violated his Fourth Amendment rights and that the conviction must be overturned. Though the prosecution argued that the officers acted in good faith, relying on the child's consent and a warrant they believed to be valid, this court finds those justifications insufficient under constitutional standards.
First, the warrant used to enter Mr. Davis's home was not signed by a judge. The Fourth Amendment explicitly requires that warrants be issued upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. A critical component of this process is a judge's signature, which affirms that a neutral magistrate has reviewed and approved the warrant. In this case, that safeguard was not met. A judge's after-the-fact claim of intent to sign does not substitute for an actual, verifiable signature. Second, the consent allegedly given by Mr. Davis's 11-year-old son is legally problematic. Considering state decisis, courts have long recognized that children may not possess legal authority or maturity to provide informed consent to a search of a home, particularly when the adult homeowner is present and has explicitly refused entry. The presence of multiple officers, their assertion of authority, and the presentation of a questionable document may have intimidated the child. Therefore, this court cannot accept the son's actions as valid consent. Lastly, the good faith exception, as established in United States v. Lennon, applies only when officers reasonably rely on a warrant issued by a neutral and detached magistrate. That exception does not apply when the warrant is fashionably deficient, as it were here, due to the lack of a judge's signature. The warrant was not valid, and the officers had no obligation to recognize that. An office may not violate due process according to his or her ignorance.
The exclusionary rule exists to deter precisely this kind of unconstitutional search. To allow a conviction to stand based on such flawed procedures would weaken the protections the Fourth Amendment guarantees to all citizens. The conviction of Perry Davis is hereby overturned. All evidence obtained in the unlawful search of his home is inadmissible, and the case is remanded for further proceedings consistent with this opinion.